Hey everyone, Harry here to talk about a nasty tug of war that's gone to a lawsuit now between Texas and the federal government involving potential disclosure of women from Texas who seek abortions out of state. All right, so in the wake of Dobbs, an actually unresolved question, Brett Kavanaugh did an opinion that made it sound as if he might go the other way on this question, is what about criminal penalties imposed on state residents, but then those residents, those women, go out of state to get abortions. Now, as most people know, there's a law in the healthcare field, HIPAA, which really rigorously protects the privacy of healthcare information. A case that comes to mind is a hospital worker getting in the files of some celebrity, giving it to a newspaper. That's a serious crime. They went to jail. And, that is the law. It's a federal law, protects privacy. In the wake of the Dobbs decision, as states were really rattling their sabers and looking to make extraordinary efforts potentially, it hasn't come to this yet, to go after women who leave the state and have abortions, or anyone who facilitates it. I mean, there's a real, Orwellian prospect here in some of the most zealous pro-life states of trying to chase down people who go elsewhere for abortions or help them get abortions, or this is also part of, order in the pills, that package of medications that are responsible for over half the abortions in this country. States want to get at that. Pro-life zealots want to get at that. All right. To protect the privacy of patients seeking reproductive health care, there was in 2024, the federal government, the Health and Human Services Department, promulgated a rule just giving extra oomph to the privacy protections of women or people seeking reproductive health care, making it basically impossible for states to serve subpoenas on people who've had abortions. Give us all the information, where'd you go, et cetera. Or take the Fifth Amendment, and the federal government rule says, you cannot do that. It's a violation of HIPAA and the right to privacy. Texas yesterday dropped a lawsuit against the HHS to challenge that rule. And it says, they're just trying to prevent enforcement of state law, as in fact they're doing, but because they, at least to the extent the state law enforcement would involve violation of privacy of patients' rights. But they've strengthened that. And the legal claim here, sort of nerdy one under administrative law. And for that reason, it's probably done on purpose because the Supreme Court has been, one of the pillars of its conservative agenda has been to really cut back on the power of agencies. They have coined this major questions doctrine out of nowhere to say, was this a major thing? If so, we're not going to defer to agencies. So the idea in the case is under Administrative Procedure Act, the HHS acted arbitrarily and capriciously. And that's something you can't do. You defer to an agency, but if it just sort of comes out of nowhere, does something wacky that's unconnected to the organic statute that Congress passed, that they're acting under, it can be struck down for that reason. Now, sure doesn't seem arbitrary and capricious. It seems quite clear, not arbitrary what they're doing and not capricious. It's in response to the state law, efforts and law enforcement to prevent residents of Texas from getting abortions out of state. So, the real beef here is it's interfering with state enforcement. But that can't be stated in as easy a claim. So they're going after the power of the agency to do this rule in the first place. And they're suggesting it's not tethered neatly enough to the underlying law, which is HIPAA. That wouldn't have gotten anywhere a few years ago, but now it has to be considered a very serious argument that might, in fact, wind up striking down or at least very much limiting the efforts of the federal government to protect the privacy of women who get women in Texas. And of course, this would spread to other states probably that have draconian abortion statutes, who are seeking to get abortions out of state because they're not able to in Texas any longer. So that's the complaint now. The battle it's just a lawsuit that's beginning. The United States will answer the complaint, and the first thing you can expect Texas to try to do is to enjoin the operation of the HHS reg, say, stay at district court because we have a good chance of winning, and keep it from operating while you decide whether, in fact, our claim that HHS acted arbitrarily and capriciously in violation of the Administrative Procedure Act is good. So we've had instances, including in Texas, of district judges staying cases in situations that seem wacky and have pronounced effect, sometimes even outside of that jurisdiction. That's a whole nother issue about stays. But anyway, that'll be they've now, stated the basic battle about administrative power to do this in the first place. And that's one where, the courts and especially the Supreme Court have been trending toward trimming back on administrative power. And then you'll look for the first battle to be whether or not to stay operation of the reg while the court decides it. So that's what's coming soon in Texas. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.